Yeah, I have no choice but to put you in custody. You have a felony assault, a violation of a protective order, already a felony one, and now a misdemeanor assault, and you continue to violate conditions. I'm not letting you go. That's it. I want you to understand that I mean business. He goes with you.
Listen up. Right from the jump, this courtroom clip drops us into a collision of GPS logs, protective orders, and a family torn up by conflicting statements. Over the next few minutes, you'll hear a judge who's fed up, a defendant who says he tried, and a tangled mess of said she said that the court refuses to ignore. Key players: the defendant, the complaining witness Trish, her daughter Cynthia, defense counsel, and a prosecutor who's tracking alleged post-release contact. Teaser: there's a GPS entry, a generator, and a hurricane night that becomes the smoking gun for alleged violation of bond conditions. Stay sharp. We'll break down what a protective order actually bars, why a GPS ping can be legally devastating, and how a judge decides enough is enough. We'll also point out where the testimony is unclear, where the court is drawing inference, and where the defense might have tried to fix things but failed. By the end, I'll ask you if you were the judge: custody or warning. Keep watching. We'll rewind the key moments, expose contradictions, and show why the judge says jail might be the only language that works here.
There was already some that was rolled over from the storm. Yep.
So what time do you think we'll get a panel? And then people probably cave too. What time? Tyler's texting. So what should I say? 9:30?
I mean, Judge, it's your schedule.
Yeah. Okay.
9:30, I guess.
All right. So I'm bringing you back out now because no means no. No doesn't mean maybe. No doesn't mean there's got this going on. If you really wanted to, you can always use someone else to achieve a goal. You don't have to do it yourself.
Okay, pause. This is a textbook moment where the court reads alleged post-release behavior into the record. When the judge says, "Now it's come to my attention," that's a legal flag. Information has reached the bench that could alter bond conditions or trigger contempt. Two critical legal points here. S1's protective orders and bond conditions can include no contact terms enforced by both misdemeanor and felony courts. Violating them is not a minor paperwork problem. It can be a new criminal violation. A 2. Corroboration matters. The prosecutor is relying on a witness statement and a GPS log. The defense will try to minimize the significance by calling it a misunderstanding. But when GPS and witness statements align, courts treat that seriously. So when the judge frames this as, "come to my attention," expect the tone to shift from advisory to disciplinary.
Now, it's come to my attention that there's a couple more issues that Damien wanted to say as far as this case was concerned.
Is that what you just spoke to me about?
Yeah, what I just spoke to you about. So I spoke to the council about it as well. The issue that we're having is that the defendant is contacting the complaining witness against the bond conditions of what you have put on for him. We talked to the witness in the past. She said that they were still talking together, and after he left the jail, that they were at a hotel together. Also,
Watch this. The transcript shows the court is juggling multiple witness statements. Logan's report, the daughter Cynthia's statements, and conflicting accounts about whether Trish was present. That's credibility central. Judges don't love, said she said, but they do rely on consistency and contemporaneous records. The prosecutor is trying to stitch together a timeline. 2 weeks ago Trish called Cynthia, and defendant covered her mouth. That increases the perceived seriousness of the contact. From a defense standpoint, casting doubt on dates, motives, or memory could blunt the impact. But when an allegation also dovetails with a GPS entry or other objective data, the credibility battle tilts toward enforcement. For viewers, notice how the court treats inconsistent statements. The judge repeatedly points to uncertainty, but ultimately focuses on the pattern.
Recently, Logan, the 88 here, had a conversation with the witness who said about 2 weeks ago, Trish called Cynthia. Trish was walking barefoot after defendant covered her mouth to stop her from yelling so that Cynthia could pick her up.
Okay, well, so Trish is the complaining witness, right? Cynthia is the daughter,
Yes.
Yes,
both of their biological daughters.
yes.
So he's the father, she's the mother of Cynthia.
Yes.
Judge.
Okay, so Cynthia is getting in contact with you guys, saying that he's continuing to maintain contact with them. The problem is that I'm not the only one. The felony court has also told you not to have contact with them.
So,
She also said the defendant had no contact with the complaining witness since right after he got out of jail the first time. So it seems like she's going back and forth on the situation.
so we approached first, and then you asked Logan to go out and call for clarification. So when he went out and called for clarification, he came back in and he said that she told him that that Trish was not there whenever he came over, and that he has not had contact with Trish since he got out of jail. So, and Logan emailed that to me to show me what it is that went on in that conversation. So that's the notes that I have, is that the daughter said no contact.
All I have here is a bunch of
This is the moment technology enters the courtroom. The fact remains, because it's on your GPS monitor. GPS logs are not dramatic testimony, they're cold, objective data. In bond violation hearings, courts love objective anchors, timestamps, location pings, messages, because they remove some of the fog of memory. That said, GPS isn't bulletproof. Defenses can argue range inaccuracies, shared devices, or legitimate explanations like, I had to pick up a generator. But remember the bigger legal picture. Even if the defendant claims noble intent grandkids generator, the rule is binary. If the court ordered no contact, no entry, presence at the location can still be a violation. The judge's response, incredulity plus a no means no posture, shows the judiciary's shift toward enforcement over explanation when prior violent allegations exist.
he said, she said, right? But the fact remains is that you're still going over there because it's on your GPS monitor. And you went the day before the hurricane.
Sir.
You're not supposed to go there.
Oh, it was the day of the hurricane. Yes, sir.
That was the day before.
No, the day before was on the 7th. At least that's what they're saying. That's on the GPS device.
That hurricane came that night.
You were not supposed
Sir.
to go over there.
I just went and picked up a generator.
This line is emotionally loaded. I just want to picked up a generator. I had grandkids there. It's a classic defense tactic. Present a human, relatable motive to counter a legal restriction. Judges see it often caretaking or necessity defenses that try to humanize what's alleged as intimidation or stalking. But look at the transcript. The judge refuses to let emotional context excuse violating a court order. That's not hypocrisy. It's the court's job to protect safety, even from paternalistic explanations. For the audience, it's tempting to sympathize with, I had grandkids. But courts treat protective orders as preventative tools. Exceptions made for motion can create dangerous precedents.
Nobody else can do it. And I had grandkids there.
You're not supposed to go over there. No means no. No doesn't mean I have a generator. I've got the tooth fairies going over there to pick up a damn tooth so I can give it to Cynthia.
It won't happen again, Your Honor. I promise.
I don't care. No means no. We've already dealt with this over and over, and you have 2 open felony cases and you have an open misdemeanor. There is strict compliance that is required,
Yes, sir.
and that's it. If I let you go, then you will continue to have contact with him. And I want you to know that you were already ordered not to do anything. Already, not only by me, but by the felony court as well. So I wasn't the only one that told you not to have contact with him.
Now the defendant leans on rehab therapy, medication, coaching, all things courts want to see. But the transcript highlights a legal truth treatment doesn't erase risk. Judges weigh progress against conduct. If someone repeatedly violates orders despite therapy, the court must consider public safety and the complaining witness's protection. The judge says she's seen psychiatrists and been doing everything, yet the violations persist. That tells the judge that stated rehabilitation may be sincere but insufficient. For producers, this is a teachable tension. The courtroom isn't just a healing space, it's a risk management system. Rehabilitation helps, but it doesn't replace enforcement when behavior continues.
It's all in the same case, Your Honor, and I haven't been around Trish at all.
To be clear, we're saying that he's had contact with her. The only statement that I have here from Logan and speaking to so no one has talked to the complaining witness. The daughter, Cynthia, said that they have not spoken to each other, that she was not there when he went over. I get he was not supposed to be there, just making sure that we're clear on what it is that happened. So
I understand. The fact remains is that he's still going over there. And I have a problem with that when you have 2 open felony cases and a misdemeanor assault against this person. You know, you scare me. You truly do. And I want you to understand that I mean business. And the only way is by putting you in jail. Because if I don't, then I'm enabling this behavior and I'm telling you that it's okay for you to do it, and it's not.
I've been seeing a psychiatrist, therapist, and a coach.
And it's still
Everywhere.
not working.
Yes, it is, Your Honor. They've had me on medication. I've been doing everything I'm supposed to do and staying out of trouble. They even called me today, but I've been here. I'm doing my,
You truly don't get it. You were not supposed to go over there.
I understand. I do.
If you really wanted to achieve that goal, you could have called a friend to go pick the generator up and said, hey, I can't go over there. There are other ways of achieving a goal than you going over there.
I tried, Your Honor. I tried everybody.
Then
But-
don't get it.
It won't happen again, I
It's
promise.
not, no, you're right. It's not going to happen again. Yeah, I have no choice but to put you in custody.
Boom. Here's the enforcement pivot. I have no choice but to put you in custody. That's the judge signaling that warnings failed and that incarceration is now the calibrated response to deter further violations. Legally, the judge cited a portfolio of offenses, 2 open felonies, a misdemeanor assault, and prior protective order violations, and concluded supervision wouldn't be enough. What to note, the judge isn't punishing because of feelings, she's applying proportionality and deterrence principles. Also listen to defense counsel trying to reframe the felony misdemeanor as the same transaction. That's an attempt at legal context to reduce perceived pattern. The judge remains unconvinced. For viewers, custody here is both punitive and preventive. The bench wants to send a clear signal that court orders have teeth.
You have a felony assault, a violation of a protective order, already a felony one, and now a misdemeanor assault, and you continue to violate conditions. I'm not letting you go. That's it. I want you to understand that I mean business. He goes with you.
Can I ask you how long is this for, or what's this?
I don't know. I don't
the
know.
misdemeanor assault and the felony are the same transaction. It's the same day, so it's not like some pattern of ongoing violence here. He has no criminal history. His PSA is a 1 and a 1.
I'm not.
I
I want to get the message across. Okay. A little jail therapy, and let's see where we go. Sam, am I out to kill people?
I mean,
I don't, you can't justify it. There's 2 open felony cases and a misdemeanor assault, and he's still going over there in violation of everybody's conditions. I'm not out for blood. I'd like a little therapy. And then, I don't know, what do you think?
Well, we have a probation offer on right now, and I'm talking to felony right now to resolve all of them. Middle of talking about that right now. But I do think there needs to be some type of therapy. But it seems like he's already, based on what he
He's
says,
been in counseling, yeah.
which is good to hear.
He was in yeah, he was talking about wanting to do it whenever I first met him in custody.
Council and I, we can talk really quick. We didn't hear about what happened with his medical episode. Is it that fine?
He's claiming his sugar and all that. I still need to get him out of here so he can.
And when do we put him on for Friday? And then I'm willing to, if you're okay with it, either reinstate or, damn, those skills really got me by the boo-boo. Either letting him out, reinstating, and let's see if he gets the message. I'm not out, this isn't a capital one, right? But I want him to understand that we mean business, and hopefully a couple days will be sufficient for him to get the work. The fear of not knowing when you're going to get, it's the worst. It sucks. It's awful. And hopefully that'll be enough. And we'll go from there. I agree with you. It's not the worst, but nevertheless, it's still a violation. And when you have 2 open and then another 3 open, I'm not down with that. Really. So come back Friday.
Quick professional wrap. The judge found a continuing pattern of contact and conditions violations, anchored by witness statements and a GPS log, and decided short-term custody was necessary to enforce compliance and protect the complaining parties. Key takeaways: and protective orders are strict and enforceable. 2 objective evidence like GPS can be determinative. 3 claims of good intent or ongoing therapy matter, but they don't automatically excuse violations. And 4 judges balance rehabilitation against public safety, and repeated breaches typically pivot the court from supervision to incarceration. This outcome sends a clear message: compliance is non-negotiable. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.